Welcome to Hull & Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Susanna Popovic-Montag. The podcast you're listening to will provide information and insights into estate planning in Canada from the offices of Hull & Hull in Toronto. Here are Ian and Susanna.
Hi, and welcome to Hull & Estates and Succession Planning. This is episode number 219. Hello and welcome back to Hull & Estates and Succession Planning. Susanna and I have taken a slight pod break, but we're back on air 2011 with lots of vim and vigor and all kinds of topics that we want to cover over the next year. We hope everybody had a nice holiday season, and although we're well into January now that this podcast is being launched, we want to welcome everyone back from our little podcast break. Over the holidays, and sorry, you'll notice that Susanna isn't with me today on either side, and we're podcasting without her, and she'll hopefully be back for our next one, if not the one after. She's engaged in big mediation right now. I wanted to start off with this year with a podcast about the year of 2011 and something that I'm trying to do more with my clients, and I'm hoping that people are trying to consider generally when we're dealing with estates and trusts and potentially or actual contentious matters with estates. And over the holidays, I had some time to read some books, and one of the books I read was a book called Start With Why. And it is a book by Simon Sinek, and it's on our preferred reading list on the web page that we have updated regularly, and the link to the book is there. But it talks about starting with why, and I thought what might be a good idea for and I'm going to start pushing on my clients to do is let's start with why when they come to see me about dealing with A, estate planning issues, or B, dealing with contentious estate planning matters. I often face the different types of litigation that we see in our office with a great deal of hesitation. I know the turmoil and the pain that the litigation will be for the client, and it's like telling a teenager about the risks going forward. They don't understand them until they've lived through them. So there's a certain amount of, I find with my clients, a little bit of my warnings go on deaf ears. And that's okay, of course, and it's appropriate because that's a personal choice that the client wants to make. But it seems to me that we need to press back and consider why. Why exactly are we pursuing the litigation? And consider today the question of why in the context of the types of contentious matters that arise certainly in every day-to-day practice. The two key components to any matter that we at our office that we deal with is one, communication, and two, transparency. Communication about what we're thinking, about how we're seeing the dynamics unfolding as the litigation or as the contentious proceedings move on. We are always working at better communicating those thoughts and those concepts to our clients to keep them up to date, A, but B, to let them know where we think the matter is proceeding, both from a strategic and from a legal standpoint. And secondly, the transparency between both the client and the individuals, individual lawyers, and of course the transparency within the litigation. We need to obviously we hold our cards close to our chest and are there for the number one goal of protecting our clients' interests, and sometimes the transparency can be so important. And where transparency can be so important is, of course, in one of our general themes throughout our podcast is when planning. Forget the contentious side, because that can be tied to strategic advantages to proceeding and certain information being disclosed at certain times. But on the planning side, the strategy tends to be more wide open. And again, I will ask myself and ask my clients to consider why. Why do I want to communicate my future thoughts in terms of my estate plan? And why do I want to be transparent? Well, we've talked many times in our podcast about the benefits of the why, the benefits of transparency and communication. But I was thinking about it when I was reading this book, and what is the why? When we wake up in the morning and we consider pursuing our estate plan, or we consider pursuing a litigation plan within the context of our estate, why are we doing it? And I like to ask myself, and I'm going to use 2011 as a reminder to me to ask my clients too, when they come to see us about a contentious matter. For example, we have a series of podcasts that deal with how a will challenge proceeding is conducted. And we have my father's video online where he explains, in his views, some of the real core components of a will challenge and a piece of will challenge litigation. That's the what. And we have dedicated our website, and we're continuing to dedicate our website to the what. But why is only answered by the client. And certainly from my perspective, I'm going to start to be more vigilant to ask the clients why. And why do they want to engage in the litigation? Is it a variety of factors? Is there more factors? Is it more overwhelming than the other? And that will challenge litigation is an easy illustration of that. Because the why to pursue that litigation is a choice. And it's a choice, whereas when we have dependence relief applications or situations where our clients or we're defending them or in the context of a dependence relief application, it can be the what in the sense that they need the money. The spouse has not been properly treated, not given enough money during his lifetime. The will does not provide for it, so you bring a dependence relief application. That's because the what is, I need money for my client. Whereas when we get back to the why in the context of estate litigation and will challenges, sometimes it's about the money, but sometimes it's about far more than the money. And what we're finding more and more when we're pressing on that issue of the why, we're absolutely capable to do the what. The why helps us deal with the what. Once we get a better understanding of why our clients are proceeding in the way that they want to proceed in the context of the litigation that they want to proceed, that can have a tremendous impact refining and directing our litigation in a very surgical and a very pointed way. And it seems to me that's where the efficiencies can start to come to play in the context of the what. So I've used why and what back and forth, and in the context of two different choices: a dependence relief application where the what is we need the money, and where a will challenge is where the what is where the why is not necessarily driven by the money, and is driven by different factors why they are pursuing that litigation. So I look at the other kinds of litigation that we are involved with, and I think to myself, from our perspective anyway, when we're looking to remove a trustee, the question of why needs to be answered at the outset, or at least needs to be framed at the outset, so that then we can proceed with the what. If we're not happy, my client is not happy with the actions of the existing trustee, why are we trying to get them removed? Well, is it partially because they're putting the estate assets in jeopardy, or is it partially because we just don't like them? And once we can drill down on the why, we can then create our plan going forward and our what going forward. So, again, I thank the author, Simon Sinek, for alerting me of the why and the what distinction. I hope I haven't been too confusing with the why and the what today, but I thought that it was a great way to illustrate our starting point into what is going to be an exciting year of podcasting with myself and Susanna, and we look forward to being back on air more regularly after we've taken our Christmas extended break from podcasting. So welcome back to everyone, and I look forward to our next podcast. Thank you very much.
You have been listening to Hall on Estate and Succession Planning by Ian Hall and Susanna Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Ho podcasts or leave any questions or comments, please visit our website at hollestatemediation.com.